Good afternoon, or I guess good morning for some. Thank you for joining our discussion on navigating due diligence, a comprehensive approach across compliance, operations, and cybersecurity. I'm Allison Fraser, a managing director at Salus GRC. I provide regulatory compliance consulting services to an array of clients, including registered funds, private funds, and institutional clients. Prior to becoming a consultant about 10 plus years ago, I was in-house as an institutional manager and responsible for overseeing the compliance due diligence program for over 250 sub-advisors and investment funds. With me today, I have Adam DiPaolo and Stephanie Monaco. Stephanie is a partner with the law firm of Mayer Brown in their corporate and securities practice. Her work focuses on investment management clients, including SEC registered advisors, investment companies, private funds, and dual registrants. Stephanie started her career in the SEC's Division of Investment Management, left briefly into private practice, and then returned to the SEC. Since that time, she has now been in private practice. My colleague, Adam DiPaolo, is also a managing director in the regulatory compliance practice at Salus GRC. Adam has over 20 years of experience in compliance and law. He has a focus on a broad array of regulatory compliance expertise with advisors to private funds as well as traditional and internet-based wealth managers. Prior to consulting, Adam was in-house counsel at an information technology company. Today, we're here to speak with you about due diligence, and our learning expectations for today are understanding regulatory compliance expectations, nuts and bolts of a customized due diligence program, M&A due diligence, terminating service providers, and what are our key takeaways from having a proactive due diligence program. We appreciate your participation. I think those of you can see that there's a Q&A opportunity in the inbox. Just go ahead and type your questions and we will answer them. If not during the presentation, we'll do our best to get back with you shortly thereafter. So why compliance? Why compliance? Why due diligence and oversight of service providers? I think we all know that the golden rule for outsourcing is you can outsource the work or the activity, but not the responsibility. So what are the current regulatory expectations pertaining to oversight of service providers? I think Stephanie is going to speak with us about the proposed rule making with respect to oversight for investment advisors. But, we do have currently rules that incorporate due diligence in various respects. For example, Rule 20647 of the Advisors Act requires that advisors adopt written policies that address risks associated with an advisor's activities and are designed to prevent violations of the Advisors Act. So if you're outsourcing, that could potentially be a risk that you would need to define in your policies and procedures. Similarly, in the Investment Company Act, Rule 38A1 also requires that investment companies adopt policies and procedures reasonably designed to prevent violations of the federal securities laws, including policies and procedures that provide for the oversight of certain key service providers to the fund. And not to be forgotten, the NFA has issued an interpretive release regarding to its members regarding the use of third-party service providers. It requires that members must have a written supervisory framework over which its outsourcing functions are reviewed and monitored. And FINRA has also sent its members a notice regarding its obligations to maintain a supervisory framework for activities and functions of third parties. The notice suggests that the system it develops should address supervision, registration, cybersecurity, business continuity. And there are also other rules under the regulatory framework in which registrants operate, such as Reg S-P and in the investment company space, Valuation Rule 2A5, that also have components of service provider oversight. So there is definitely regulatory expectations, or there are definitely regulatory expectations around service provider oversight conducting due diligence. But there's also a pending rule out there. And Stephanie, what are your thoughts about the outsourcing by investment advisors rule, where it stands, and kind of what the components of that rule are?
Thank you, Allison. Yes, there is a proposed rule, and it was proposed in October of 2022. Investment Advisor Release 6176, if anybody wants to look it up. I, for formal legal terminology here, would throw out that I think the rule is absolutely unnecessary and falls into the duh, of course, category. This proposed rule, and when I do think about due diligence, I think about it. In fact, when the SEC thought about outsourcing in the proposed release, I went back and I found that they had used the expression due diligence 246 times in a release of about that length. So due diligence in the registered advisor space certainly is synonymous with this outsourcing proposed rule that, in my opinion at least, I think the rule is just as unnecessary as the proposed express suitability rule that the SEC proposed many years ago and never bothered to adopt. It's embedded within fiduciary responsibilities. And if you need sort of to connect up on fiduciary responsibilities, I encourage taking another look at the fiduciary standard of conduct interpretation from June of 2019. So what is this proposed rule? And again, as evidenced by recent examinations and my own sense, I think it's already live. What are the expectations that are enunciated in this proposal? It is due diligence at the before, during, and after stages of retaining a service provider that falls within at least the SEC's notion of covered services, or covered functions. Those are functions that are necessary to provide advisory services, and that if they're not performed or if they're performed negligently, would likely cause a material negative impact to clients. In this rule, the SEC sets forth 6 due diligence requirements. Identify the nature and scope of the function, identify how to mitigate and manage risk to clients or the advisor resulting from an engaging a service provider, determine the competence, capacity, and resources of the service provider. Again, they articulate requirements. I consider that to be part of the duh regime here. Determine if the provider subcontracts a material portion of what they're supposed to provide, and whether the subcontractor to the outsourced vendor is qualified and able to perform those services. Here's a good one. Obtain assurances that the provider is able and will coordinate with the advisor in efforts to comply with all of the federal securities laws. Try negotiating that one. That's interesting. And lastly, obtain assurances that the provider is able to and willing to provide a process for the orderly transition upon termination. We're going to come back to that in a minute. It's a rather lengthy release, and you can cherry pick the portions that you like. Jumping to the quick, where you can get a glimpse of what covered functions at least might be from the SEC's perspective. It includes sub-advisors, client servicing, cyber security, we're coming back to that in a minute, investment guidelines and restrictions, investment risks, portfolio management services, portfolio accounting and accounting services, pricing, reconciliation, regulatory compliance, trade desk functions, trade communications and allocations, valuation, and other, whatever that is. So this is a list that the SEC has proposed will be included in another amendment to the ever-growing Form ADV. The due diligence requirements really are a before, a during, and an after. So before you go out and hire a vendor to perform covered functions, and I would say insofar as that is a very broad definition, it's just about any third party or affiliated service provider, you need to kick the tires. You need to request a lot of documents. You need to consider very, very seriously what their template contract is and how you can modify those template requirements to cover this big lift, which is they're agreeing to keep records, for example, to assist you in connection with complying with the federal securities laws. Depending upon what the service is that's being outsourced, you have to ask yourself the question, well, do we need to have an MNPI policy? Do we need to impose, and would the vendor be willing to accept an insider trading policy, particularly if they have access to confidential client information? Once you can get over the hurdle that they're qualified, that they're willing to do all of these things, then periodically during the existence of the contract performance, you need to monitor that. Well, what does that mean? Does that mean once a year you give them a questionnaire? How are you doing in connecting our record keeping obligations to yours? Are you monitoring for compliance with the provisions in the contract that we've imposed? How is your competence? Have you had client or customer complaints in the prior period? What do you do if you find that there have been customer complaints? Is that an automatic red flag that should make you pull the plug on that relationship? And then the after, which I have found through the years to be kind of difficult. Your contract might say that all books and records that are being maintained in connection with the service belongs to the investment advisor, and upon termination, the vendor will provide access for what period of time. What comes to my mind about the more difficult aspects of terminating a vendor relates to performance records, that you may select a vendor that is helping you calculate your performance, keeping the records that are necessary to determine what that performance is, maybe even a vendor that is helping you claim GIPS compliance, and then you have a falling out and you terminate the relationship. And of course, where things bad can come to worse, let's say at the same time you're terminating, the SEC examination division knocks on your door and says, hi, we're here. We're going to take a look at how you're marketing your performance, produce all the records, and you've had a falling out with the vendor who's been maintaining them. That's a very rough situation to find yourself in. Walking away, you can't, and you can't make yourself feel better. Well, we could sue them for damages, because that's not going to help you if the examination team is unhappy with your level of possession of those records and you can't produce them. So, but as I said earlier, and Allison and Adam, your views on this, I think we're in this state now. I don't think we need this proposed rule that's almost 2 years long in the tooth to be adopted in order to face these. What do you see and how do you find things?
I completely agree with you, Stephanie. I mean, we've been talking about vendor due diligence or due diligence generally for years, right? As you go through the list of all the covered service providers, I wonder, is this just their way of, we've always ranked service providers or vendors, look at the criticality that they are to your business, what kind of information they have. I don't know if this, in my best case scenario, the SEC being helpful to encourage you that these are the critical ones. Otherwise, it's just this long. That's my best explanation for it. But we've had to do this for years, right? And they certainly have I think complicated it by mandating it in this very long, confusing rule. But these aren't new responsibilities, right? Just as part of your fiduciary duty, the supervision and of anything you're outsourcing, it's still your responsibility. They've been saying that for years. So I don't think it's new, but it does. I think it does complicate. It will complicate everyone's documentation. It is obviously shining a spotlight on where the SEC is going to start dinging people next once this is passed. So why don't we get into it? I mean, because it's so robust. Allison, why don't you talk about it?
Yeah. No, I agree with you both. I think it's already covered in some of the existing statutes that and rules that I mentioned, but I also think it's just part of fiduciary duty and fiduciary responsibility. And as you look at having under 20647, you're of the Advisors Act, you're required to assess the risk to your business and develop policies and procedures. This would certainly be a risk. So it's already there. You already have that responsibility. But I think as we, move from the regulatory framework in which we're operating or maybe operating, depending upon what the SEC does, I believe, Stephanie, it's on the regulatory agenda for next month, right? For October?
I take your word for it if it is.
I'm pretty sure it is, but doesn't mean anything. Can be pulled off the regulatory agenda as well. I think it's in building and establishing the nuts and bolts of a customized due diligence program. There are certain kind of steps that you need to take beyond what's on this chart here in terms of fact finding and DDQs and RFPs and due diligence finalists and kind of screening. I think the first thing an organization needs to start with in terms of building and establishing a proactive due diligence program is understanding that it takes a village. It's not one person. You cannot rely on the expertise of one person within your organization to evaluate all types of vendors and to oversee all types of vendors. I think you need to consider what the function is, bring in somebody with expertise around that function, bring in the people who have the day-to-day responsibility of interacting with that vendor. And then you also have to consider who the decision makers are going to be. And, what's the process you're going to put in place? And are the decision makers outside of the due diligence framework so that you're getting an independent assessment or a fresh set of eyes as to, who you want to engage with? I guess one of the questions I have, and actually somebody asked it, Stephanie and Adam, in our chat box, is, how far back do you have to peel the onion in terms of your responsibility with respect to establishing your due diligence program? If you engage a service provider and they use service providers, how do you have to do the due diligence on the underlying service providers, the ones, 1 or 2 or 3 times removed?
I would tell you that regardless of the answer of what the expectation is, in many cases, it's impossible.
Mm-hmm.
You know, you're working through the primary vendor and asking questions about their subcontractors. If it's a large company and you are a small advisor, you don't have that kind of power. And so the best in most circumstances, it depends how big you are. You know, here's where size sometimes does matter. You have to look to contract terms ultimately to get yourself to a level of comfort, because you can in your RFPs and DDQs, you can and should ask questions associated with what do you do with your subcontracted vendors that you use in order to deliver these services to us. And you can ask those questions, and depending upon the circumstance, you might get an answer and you might not. In your contract negotiations, though, one thing that I think you definitely want to include is that while it would be best to say you cannot delegate or subcontract any portion of this work without our permission, you're not likely to get that. Instead, I think what I would probably encourage and hope that the vendor would agree to is, to the extent that you delegate any of the services we are contracting for here, you remain primarily responsible for the delivery of these services. And like I said, I mean, you know, I think that might be the best that you can do where it comes to subcontracting work out from the vendor.
I think that's a great point. I think that's a great point. I mean, and it lines up with our fiduciary duty. That's what the investment advisors are sort of stuck with, right? They ultimately cannot let go of the responsibility in the SEC's eyes, and you've got to hold your providers to that standard in your contract. Hopefully, the same thing. I think that's a great one great way to think about it. Since you talked about DDQs, did you want to add, Allison? But since you were talking about DDQs, no. We could move on to the method.
Yeah, that you know, it's not a one-size-fits-all approach to due diligence. There are different methodologies to get information from a provider, and I was going to ask you to, you know, kind of go over some of those tools and how you select what you're going to use.
Yeah, I was going to say, I mean, one of the common approaches that Stephanie mentioned is really the DDQs to gather a lot of the information, but there are a lot of tools available and different methods you can use for your diligence. You know, you can supplement those with attestations or certifications. You can get SOC 2 reports or ISO certifications to verify that the providers you're using are maintaining their controls. It might call for, you know, regular calls and meetings, depending on the criticality of the vendor or the service provider. So you can stay on top of operational changes. It's also part of your relationship management and oversight. And then lastly, I think third-party assessments, I think they can play a really key role. So mentioning SOC 2 reports, third parties drafting those reports, but you may not have the expertise in-house for some of these things. And when we talk about cybersecurity, that's the one I think most often we hear clients asking about or thinking, you know, as a CCO, that may not be in their wheelhouse. And if it's a small firm, they may not have someone to help them assess the information that they're getting back. So they're going to look to third parties. So there's a lot of different tools at your disposal when we're talking about diligence. And I think it really comes down to, you know, the facts and circumstances around the particular service you're looking to fill, or what the provider is actually doing for you, how critical that is, you know, what kind of information they'll have, and other factors of the relationships for how you deploy the various tools. But why don't we get into the specifics a little bit of just talking about diligence on service providers themselves and getting into more nuts and bolts of different scenarios there.
That sounds like a good idea, Adam. The one thing I did want to say when relying on third-party assessments and third-party reports is you need to make sure that what was assessed by the third party, the activities or the controls, are controls that are applicable to the services that you're getting. So for example, if you get, some kind of custodial report or SOC 2 or something on your custodian, but you're not using them for cash, and most of the report refers to their cash controls, you need to make sure then that you get the information that relates to the service, and not just say you relied on a SOC 2 that has nothing related to the services they'll be doing on your behalf. So I know Stephanie feels very strongly about this, and we are going to talk about making sure the materials you are looking at the materials that you get. But I just wanted to mention that with the reliance on third-party assessment is that they need to be relevant to the services that you're providing. I think with respect to due diligence, it does come in different shapes and sizes, and it starts with initial due diligence. So at the very beginning, you may be having, you may be looking at more than one vendor and conducting due diligence to determine who you're going to select as your service provider. And then once you've made that selection, there's an ongoing monitoring component that is based on the activity that they're doing on the firm's behalf, but also risk that they represent to the organization should they not be able to fulfill that responsibility. And what would the impact be to your business? Of course, I think cybersecurity and data security, information security risks are probably permeate just about every type of outsourced relationship, because we all rely on systems to communicate information, and we need to make sure that the communication that we're having and the reliance that we have on applications and systems is protected and is secure, so that we're not inadvertently risking privacy with personal identifying information or the like. I don't know, Stephanie, what are some of the best practices you see around conducting initial and ongoing due diligence and putting out?
One thing about the monitoring that some of the outsourcing activities might lend itself to are KPIs and objective measures of more or less confirming back with objective qualitative factors that they continue to do a good job. I think I'm being very amorphous and broad about it, because every outsourcing situation, it depends what you're outsourcing. But one thing that you can't deluge a vendor with too many questionnaires or too many periodic confirmation demands of attesting to certain quality and qualitative measures of performance. But some of that is very helpful, maybe once a year. And again, it's hard to describe best practices with a specific enough detail to be useful, because it really depends upon what it is that you're outsourcing.
I think that's kind of dovetails into what we were going to talk about a little bit, just as part of your initial diligence, right? You Allison, I think you just mentioned you're already assessing who the right team is, but you're assessing the risk of the particular vendor, the criticality of the relationship, and I think Stephanie, to your point, that can inform, or it does inform, both the level of diligence that might be required on an ongoing basis and the frequency, right, of the monitoring. I mean, and it really does depend on the specifics of the given situation. Ranking, so we see folks ranking their service providers based on risk to inform how, the frequency of when they go back. Obviously, high risk providers, you need to visit more frequently, and maybe that means even on-site for some of those. What are your thoughts, Allison, on some of the frequencies?
I think risk ranking is very important. And it's important for two reasons: not only to have establish a reasonable program, but also to take into consideration your resources. I mean, none of our firms have unlimited resources that you can dedicate, substantial resources to doing the same thing for each service provider. There are levels of activity and responsibility that you've delegated to service providers that are more critical to your business operations than others. So, for example, if you distinguish between a service provider who is actually performing an activity on your behalf, and but for the fact that you had engaged this service provider, you would have to hire people, as opposed to a vended solution where you are using an application. You're still doing the work in-house. So maybe there you only need to understand what the cyber controls and the information security controls are, because you have access to the information, you have control over how it is getting done. You don't really need, they're not really doing the activity on your behalf. And I think where you have someone doing the activity on your behalf and the risk profile is higher, you need to consider then what's appropriate for what is it they're doing, what type of information do they have access to? Is it personal identifying information? Are they moving cash? Are they moving securities? Are they, if they have, if they're, that would be critical to your investment advisory services or the services that you're providing to your clients, then obviously you need to increase your oversight and have that on a tiered level.
And I would want to add to that by using a very common outsourcing situation people may not think about. When you place trades through a broker-dealer, you are outsourcing a critical function of the delivery of your advisory services. That is a model that's pretty much already, that's a mousetrap that's been created already. So what do you do to monitor the quality of the trade execution that is so critical to the delivery of your advisory services? You have a best ex committee. They get together on a quarterly basis. They rank how their brokers and dealers are performing in connection with executing the trades that you are placing through them. You rank those brokers and dealers. What I see sometimes is that some of those outsourced broker dealers who are executing the trades for you don't do a great job. Their errors, their mistakes, they're slow on the uptake. They're not really doing a great job of delivering best execution to you and your clients. It's fine to have all that memorialized, but what would not be fine, and what I see, is there's no follow through. If you set for yourself a trade execution budget, so to speak, in the beginning of the year, you're going to place X percentage through one broker, Y percentage through another, so on and so forth. And at the beginning, at the end of the year, you've met those targets, but during the year, one of those brokers did a really lousy job. You've got an optics problem in terms of how you are monitoring that vendor. You should not have continued to allocate that amount of trade execution to a broker or a dealer that is doing a lousy job for you.
Yep.
That's a great example of the obligation for ongoing, right? Of a real critical, one of the most critical for most firms outside of PE and things like that.
I also think, Adam, it speaks to needing then a review and escalation process where potentially the decision makers are outside of the people who have the monitoring and oversight responsibilities for due diligence, because you may have to make a decision about terminating that service provider or putting them in a penalty box or developing, other controls around monitoring them, and assess, what the risk is to the function that's performing on your behalf. So I think, it doesn't just stop with identifying the problem. It's what are you going to do about the problem? And how are you handling it?
Exactly.
So, I think in the next slide where we've talked a lot about the ongoing business relationship, monitoring performance, service levels agreement, things of that nature. There are a number of different types of oversight that you can use to make sure you have touch points with a service provider. And they may not all be with the day-to-day function. It may be with members of the legal team. It may be with members of technology doing testing and incorporating them in your business continuity plan. It may be with compliance or risk, doing an assessment of your business or your internal audit function, looking at your service providers. It could be through, attestations. It could be through having meetings where you go through and look at all the deliverables and their performance and assess their performance on a periodic basis, based on what the services they're supposed to be providing. I don't know, Adam and Stephanie, if you have other thoughts on ongoing oversight.
I just like the idea of having a regular process, which makes it easier for folks to follow, right? I think when people don't, what I see with some of our clients, or when you're going into someone new who doesn't have an established process for their diligence, and it's sort of this scattershot approach, that doesn't work very well, right? I like something that is, whether that's a checklist or something that just sort of formalizes the process and keeps it regular, and we'll talk about that just in documentation a little bit later. But I think that, for me, that's one of the main threads that's going to go through all of your diligence that's ongoing, is some sort of regular process. It can't just be, I get this from this person, and I don't know, we'll have finance go look at this person. I think really it's just formalizing what the process is.
Yeah, and I thought it was a little amusing, but it is a concept that crosses my mind. In terms of the ongoing oversight, the SEC wrote in the release, and I think we all feel the same way, an uncomfortable position to agree with them at the moment, but that it is not a set and forget situation. You cannot do that in this environment.
Mm-hmm. Yep, it's not one and done. And I think also, one of the things I think would be helpful for us to do is to just take a closer look at an example of a due diligence process. And we've used, by way of example, M&A due diligence. And I thought that Stephanie and Adam, if you wanted to walk through the process and some of the considerations around that unique type of due diligence.
Yeah, let's, to start with the M&A, I think when we're talking about M&A, we're talking about acquiring a target, and it's even more comprehensive because you're not going to terminate that relationship, right? You're taking on fully the responsibility of all aspects of a business, and you're thinking about how you can integrate it into your existing structure and your existing systems and processes. So it really, it really is an example of a comprehensive deep dive in every aspect of diligence, right? So since there's a lot to cover, we break it out, or I think of it in three pillars, a lot of, technology, legal and compliance, and then the financial pillar. And each one of those is very specialized when we're talking about M&A, and trying to handle all of that internally for a lot of firms is overwhelming, especially for smaller firms with limited resources, may just not have the expertise for that. So, just as we think about these pillars, oftentimes I see firms involving third parties in the process because they just don't have that expertise or bandwidth. For example, the one I always think of, aside from, I'm not a finance person, so I guess the two I think of are cybersecurity experts, third parties that might do in-depth vulnerability assessments, providing detailed reports to, in your diligence reports on the target's IT infrastructure, their security practices, what are the policies that they have for information security controls. Stephanie and I guess, live in the legal and compliance world. And Stephanie would, right, Mayor Brown, you would help with the complexities of contracts and regulatory filings and compliance histories. And then the financial consultants might provide a deep dive on the financial health and the operational efficiency of the business. But it is so complicated. I think using a third party oftentimes is going to help with identifying some red flags in these areas. But that's just breaking it, I think, breaking it up. What I'd like to sort of hear from you, Stephanie, is exactly what are some of the best practices you see when in M&A situations, if you're focused on the legal compliance piece or across it, what are the things that you think about the most, or sort of the critical pieces of the diligence for you?
And I'd like to kind of narrow this down a little bit. Due diligence, we've talked about one aspect about due diligence, which is you're a registered advisor and you're outsourcing or you're hiring a vendor, third party or affiliate, and we'll talk about affiliated vendors and outsourcing to family and friends. Is a very interesting area. But due diligence from a different perspective that I've been involved in on many occasions is we represent a public company that is acquiring a registered advisor, or we represent an advisor that is acquiring another advisor, or we represent an advisor that is being acquired by a third party. Those kinds of M&A transactions across the board. And I guess this speaks more in the circumstance of we are representing a company that is acquiring a registered advisor. So for you who are in attendance here, think about, well, what if we were to put ourselves on the sales block? What would a potential acquirer be looking at? Or if you want to think about it more as you're like an aggregator firm, and you've got a whole lot of registered advisors. Some are relying, most are independent investment advisors that are already registered, and you're acquiring them. What are the things that you look at and you really need to focus on from a regulatory and compliance perspective? And in each of those circumstances that we've been involved, you've got to slog through their compliance policies and procedures. It's a must. And even though you may see all these documents and say, okay, I can check they have an insider trading policy, they have an order aggregation and allocation policy, check. They have a code of ethics, check. They have, check. You really have to dive into the details of those documents in the data room to make sure they really are up to snuff. You want to pay particular attention to any correspondence within whatever the time frame of the data room and the documents are. I would say at least 5 years for prior regulatory examinations or any communications with law enforcement or any securities regulators whatsoever. Case in point of a situation where there was an exam of an advisor that our client was acquiring, and there were deficiency letters from the prior exams. Okay, I could have just checked the box. Okay, they had an exam a couple years ago. They got a deficiency letter. They're representing that they're in full compliance with the securities laws. Okay, great. I could have just stopped right there. But instead, I had to dig in. And anybody in that position, particularly when you're doing due diligence of an acquisition of a regulated entity, you have to dig in to all communications with the regulators. In this particular circumstance, the deficiency letter made my hair curl. My head went on flames, and every other expression I can come up with. I advised our client who was thinking of acquiring them, there's trouble here in River City. Of course, the business guys and folks had fallen madly in love with each other, and they didn't want to hear that it's possible that your date might have fleas. And they went forward, and about 6 weeks after the deal closed, enforcement came knocking. So it's a circumstance that the attendees on this call and you may find unfathomable, but I don't want to be an I told you so. You got to go mining for those kernels, because what you're up against in that kind of a due diligence M&A transaction is exactly what I described. The business people, they're halfway down the aisle. They've already exchanged rings and promises for the rest of their lives. They're spellbound with each other. And at that point in time, you don't want to be the skunk at the garden party, because it doesn't go over well whether you're right or you're wrong.
I think we have a polling question. I think we just have one polling question through this. Since we're talking about M&A and we've talked about affiliate, just one question for folks. Do you outsource any advisory services to your affiliates or to an affiliate? We'll just wait a few minutes for some responses to come in.
Boy, if we have to wait a few minutes, somebody's going to have to start singing a song, or we're going to have to do row, row, row your boat.
Or Stephanie, start talking about some of the considerations of outsourcing to an affiliate. How's that while we wait?
Yeah, that's fine. I think outsourcing to affiliates is outsourcing on steroids, to be honest, and it doesn't come naturally to people's minds. First of all, what doesn't come automatic to mind is, are you outsourcing to an affiliate? By definition. Most of the cases that I encounter in this space is, yes, you certainly are. You can take a real estate advisor, for example, where there's another company under common control and they do all the leasing services for you. And then there's another affiliate that's the construction arm of this enterprise, and they do all the repair work. And then, there's another segment that deals with financing and, mortgage servicing. And you're the registered advisor kind of orchestrating all of these affiliates to provide these services. Well, do you have to do due diligence on your affiliates? In some cases, it's hard for that question to just get off of your tongue, because some of your affiliates are much more profitable than you are. And for you to come in and dare to ask due diligence type questions for comparable compensation for their services, that's a biggie. And you need to nail that down. To how can you objectively assess the quality of your affiliate services. How can you objectively assess that? And when we see the examination staff coming onto these situations, they're going to say, well, what due diligence did you do on your affiliate? And, you don't want to be sort of off in la la land in that respect. Very important. Most of the people said they did not outsource to affiliates.
Yeah, we just had a handful, I think, that did, so most independent. But I think that was a great segue, right, to the record keeping, because if you are outsourcing to an affiliate or to anyone, the importance of, we cannot emphasize enough the importance of record keeping and documentation here, because if you don't have it, you are going to get no credit for having done anything. So you're going to need to really have your ducks in a row, documentation lined up, especially in the affiliate context, like Stephanie was just talking about, where you have comparables showing that you've selected this is the best person to serve, or at least comparable to anyone else, is no worse, and that your clients are you are really putting them first. So,
and Adam, I just want to add to that with respect to documentation, it doesn't begin and end with the initial due diligence. It is through the life of the relationship. So if you are getting checklists, if you are holding periodic meetings, any kind of materials that support and evidence your continued monitoring and ongoing oversight of the relationship need to be maintained, as well as any issues that you have. We talked earlier about, potentially the need to escalate something, or lack of performance, or not fulfilling, that all be documented and maintained in due diligence files for service providers, such that you can show the history of your relationship and what you've done from beginning to when it does eventually terminate. I think the thing I would add here is that to the extent you develop a due diligence program that has a consistent process for the manner in which you maintain your documents, it will make it a whole lot easier when you're asked to demonstrate that you actually fulfill this function. Yeah. So, just randomly keeping it in a file, I don't think helps anybody when it comes time to demonstrate, the fulfillment of your policies and procedures as it relates to ongoing oversight and monitoring of service providers.
I know we've limited time, so I want to keep moving on. But are there particular contractual provisions, Stephanie, that, the whole contract's important, but are there particular provisions that you think about folks should be mindful of? I think you've pointed at a few of them, I think, already. But what are your thoughts here?
Part of the if you can have indemnification provisions that run both ways, instead of the advisor indemnifying the vendor. Again, it's a question of contractual power, who's got it. Mutual reciprocal indemnification provisions are very good. Exculpation provisions saying basically, you will hold us, the advisor, harmless in the event that you make a mistake, whether it's intentional or not, and we and our clients suffer damage associated with that. That would be good. But again, it's a bargaining power. A lot of vendors, and again, it depends upon what is the outsourced service you're talking about, but a lot of vendors are going to limit their liability if they agree at all to provide some liability insurance or coverage. They're going to limit it to the fees that you pay them, and not a nickel more. So those kinds of provisions are very helpful. Definitely get in there that there will be no delegation of any of the responsibilities except upon your approval or consent. You can say that won't be unreasonably withheld, yada, yada. But if you agree to a provision like that, to be very clear, for the avoidance of doubt, even if you, the vendor, delegate your responsibilities in whole or in part, you will remain responsible and liable associated with this contract. Those are very nice when you can get them, and I think that one I would push for. Provisions to ensure compliance, again, it depends upon what's the service that is being outsourced. If at all involves required books and records, and you should make note, if this rule gets adopted, the books and records rule, antiquated though it is, will be amended again to require books and records associated with the vendor management and relationships, that they agree that first, you own them, you the advisor, or your clients, but you the advisor, and two, that they will be contractually obligated to provide them upon reasonable notice during the agreement itself, and for, I would say, at least 5 years thereafter.
Great. That I think dovetails right directly into just the importance of the termination provisions, right? So, we talked about, you were just talking about, making sure that you have access to these things after you've terminated the relationship. We've talked about, sort of the initial and the ongoing, but the termination and planning for termination really is just as important as the onboarding and the ongoing monitoring, because otherwise you need to plan in order to avoid disruptions in your service and to make sure, as Stephanie was saying, that you really do have access to your records and data. Absolutely most important when, always important, even more important if they have your sensitive data. So you should have a clear termination plan. We have just a minute or two left. So why don't we just go to some takeaways? Allison, why don't you?
Sure. I think one of the points that I'm not going to step on Stephanie's toes here, but because I think this is her main point, is to read the materials that are produced. Do you agree, Stephanie? That
I do. Reading is fundamental. Always has been, always will be.
Absolutely. The worst thing you can do is to request information from a service provider and then not look and read that information. Because if there is something buried in there that represents a risk or a violation of law that, you had it in your files and you should have known about it, it could present problems ongoing if you do end up engaging that service provider. As I think about cybersecurity and information security and what role that plays within the due diligence process, I think it should be embedded in all due diligence, because I can't think of a type of due diligence where I don't want to know about the information security and the cyber controls of a party that I'm going to be doing business with, where I'm going to be providing my business information to them and have it be used and not know is safeguarded, or my client's information. So just given the access, I want to know what their control environment is. And I think we've talked about this books and records. You don't get credit for it if you don't have it documented. And the documentation does not begin and end with selecting the advisor in the initial due diligence process. It doesn't end until the relationship is terminated. You need to be able to demonstrate that you have oversight and are monitoring your service providers through the life of their relationship. and that they're maintained in a way that you could produce the information should you be requested to do so by a regulator. So, Adam, Stephanie, other key takeaways?
Just one other takeaway. We have 20 seconds. I'll try and be brief, but that's difficult for me. Conflicts of interest. Take a look at why is a particular vendor being considered by you? Does one of your senior people get treated to a beautiful golf course once a week? Why are you staying with a vendor? Is there a conflict of interest? Conflicts of interest exist everywhere. This is effectively an expenditure of your client's money, and that is the encapsulation of your fiduciary responsibility. Whether the clients pay directly for these expenses or you as the registered advisor do it because the clients pay you an advisory fee to do so. Always look at potential conflicts of interest and dispassionately.
I think that's a great point. It was a nice, bookend on the whole affiliate question, because some of the things I've seen with folks going through exams is really when there's a related party that was serving some function or was related to a service provider, a related party of the investment advisor, might have had another business that's provided services, and those are so scrutinized. I think it's a great thing for folks to be thinking about as we end this session.
Well, Stephanie, thank you very much. It was an enjoyable discussion. I hope the audience enjoyed it. We appreciated you participating. If you have any questions, please don't hesitate to reach out to us. There will be a recording link sent to you based on your email address that you registered with. And if you have any questions, please don't hesitate to reach out to us. Our next webinar will be on October 22nd, and it will be keeping in step with ECOM's monitoring and archiving oversight. So thank you again for your participation. And Stephanie, thanks for joining us. We appreciate it.
Thank you for having me. Best of luck.
Take care. Bye-bye.